This is Tracy Woodridge, August 20th, 2023. This is part 4 in a series, The Family Court Crisis. This is the Ponzi to prison scheme and the compliance angle. In my case, which is numbered 49D161305 DR 021968 in Marion County, Indiana. How attorneys collude for fathers only. Or maybe we could say pedophiles only, or batterers only, or felons only, or money only. Our court has placed a child in need of services and an already diagnosed as abused mother in danger by denying the advocacy that is due them through court. Although we are injured and although we are suspected of mental issues and even criminal issues, we do have PTSD, which is a brain injury caused by the father and also caused by the court. They are implicit. They are guilty. Mother is diagnosed with PTSD and other age-related health issues, which are protected under law through court process, which means to discriminate against mother because of these issues is against the law entirely. The child has been diagnosed with digestive and mental disorders caused by the father, who refuses to respect the very diagnosis that the child was given by our own pediatrician and by a doctor or a therapist that he sought out after separation. The mother's side of this story has been ignored, and the case has been hijacked by lawyers and by the cluster B personality disorders that I spoke of in part 2. Our child is currently suffering in the care of the father, who hasn't had a diagnosis but looks very much like a Munchausen's by proxy disorder. Attorney Alan Reed and also attorney Daniel Keel for the father ignored the abuse factor in our household that was declared at least at separation, if not at occurrence. This kept the abuser away from criminal prosecution. How handy. They also ignored the lack of income for mother, and the father was not forced to pay his share of the bills. Mother was forced to file a $94,000 bankruptcy, and most of it was imposed debt by a father who forced mother into doctor's offices, although he did not claim me on his insurance through the Veterans Affairs, and he could have. So he was diagnosing me with bipolar. I have not been diagnosed with bipolar, and he failed to provide insurance to cover the medical fees associated with assessment. Again, I am not diagnosed with bipolar, but yet I am forced to pay doctors that he drags me to in hopes that I will get a diagnosis of bipolar. And he's there influencing them heavily, manipulating and coercing. I would know. I was there. And a bankruptcy of $94,000, which ended up to be a court-induced fishing expedition into my finances and a delay of justice, and to force me away from my privileges of driving by saying that because I was involved in an accident that wasn't covered by insurance, because the father didn't pay his part of the bills as the sole breadwinner, I had to file bankruptcy. I was deprived of my car. I was suffering from injuries because of that accident and not given medical treatment because of the father refusing to pay his portion. Although making $2,000 a month at time of separation. We'll get to that later. Mother was entitled to spousal support in 2013, but yet the hearing didn't come up until 2015, and the attorney who ordered the hearing or petitioned for the hearing and got the hearing withdrew within 30 days of said hearing because of opposing counsel challenging my mental health. After a debilitating accident, after dealing 2 years with my abuser, even with a protective order that makes him stay away from me, I cannot shake him for the life of me. And I hope it doesn't take the life of me. And I hope it doesn't take the life of our son to keep him away from me and to hold him accountable for his misdeeds, which he is responsible for, the injuries, the deprivations, etc. Attorneys Daniel Keel and Ray Feller, female, and Magistrate Murphy, male, all heard father declare that he willfully threw our child of 15 months old into a door beam, knowingly, willingly, and without my presence, threw our son into a door beam. These oath-taking lawyers all dissolved the baby's protective order, allowing full contact with father and child, no supervision whatsoever. CPS escorted the father into a hearing where he violated a protective order against himself and myself. The protective order was to protect me from him. And he was verbally brandishing a weapon, creating an attention-getting scheme or scenario, telling me all about it while en route to my home after hours without permission. There's no court order that provided for that. It was all against that. And yet the law and CPS provided protection for father, even as much as giving him a public defender, although at that time he was stating that he was making well into $500 to $700 a week. A public defender you have to qualify for through poverty. He is a working man. He was given a car at our separation, and he was provided a residence, paying only $500 a month, which is less than our marital home. And it took the court more than 3 months to get a court hearing where I would be paid child support, not back ordered, but going forward, and no damages and no spousal support. And by that time, I had already survived it. So how effective is our court system in protecting children and spousal abuse survivors? They are not. And that is my experience, not just an opinion. CPS escorted father to a hearing that was a violation of the protective order between us. CPS currently has 47 reports, all calling our son abused and neglected, and not one report is interviewing mother in a meaningful way. Our child is reportedly failing to thrive in school, socially. He's a threat to himself, a threat to his peers, and he does not take authority very well. He's being over-medicated and misdiagnosed at the same time as being deprived of his loving, nurturing, and fit mother. I've been right here all along. The child is reportedly failing to thrive as they ignore the mother's concerns and her role. Mother has been erased by the father and his aides or helpers. Double agent attorney Dawn White worked for me and attorneys John Cassis and attorney Angela Swenson, both attorneys for my ex. Attorney Brooke Bernhardt worked for attorney Angela Swenson and was the last attorney of record for my ex. Attorney Brooke Bernhardt and her, I can't remember her name all of a sudden, but the attorney that she works under, it's her association of attorneys. I did conduct an interview with them, and I believe it was with Brooke Bernhardt as she was coming away from attorney Angela Swenson, and conducted an interview with me in 2016, and this meeting is recorded in full. In 2017, my attorney, Joshua P. Stein, worked for our judge, Magistrate Murphy, or Judge Dreyer, as a clerk. But in 2017, I hired him, and he failed to do any work on the case and worked against my case by abandoning me and settling without my consent at a hearing for modification, which included a DCS report where the father was called a child molester. The child was showing up with very real head injuries, and he was already demonstrating perversions, and he was a threat to himself as well as his peers and not taking authority. And the father had already been beating this child for these incidences where he's disruptive at school, and simultaneously being medicated with ADHD medicine, which is a methamphetamine-based drug. Our son was diagnosed in 2015 with a sudden disappearance of mother with conduct disorders. So our child immediately started acting out when he was deprived of the familial relations with mother, who is nurturing and supportive and attentive in every way. He was deprived of that because of Marion County and its lawyers. Joshua Paul Stein failed to do any work for the case, unless, of course, it was working against our case. And he abandoned me in the middle of a hearing, and he settled at a modification instead of presenting evidence and testimony. He was a modest means attorney, which means I qualified for a discount on an attorney. So even at the cheapest, most affordable rate, attorneys have not provided due process and rights advocacy for me. So who else has been damaged by Joshua Paul Stein or any other lawyer of the American Bar Association? Perhaps it is time for a class action lawsuit against them because of their conflict of interest, because they just don't care about American rights. Why is that? He knew, Joshua Paul Stein knew, that I was being set up for more deprivations and more rights violations. He knew that the father wanted me gone for good. The dean of the school called my ex a child molester, and this is in bold type, italicized, and in quotations in the DCS report. And yet attorney Joshua Paul Stein in 2017 failed to present a case that has merit, a case that protected a child, that would have protected a child and reunited a mother with her child so that she could provide protection to the child and mitigate these horrible instances of abuse that continue. My attorney, Nathan Vining, in 2016, was hired to present my exonerating and demanded psychological evaluation, which I was forced to seek out the qualified evaluator, pay for the qualified evaluator, endure the evaluation, and then render the results to the court without any haste or hesitation. And that was done even without having parenting time with my child. It took over 6 months to produce the evaluation, and it was exonerating, which means that I am not guilty of anything that they had said against me. I cannot be charged as guilty for these things because of this clinically qualified psychological evaluation. And yet it was ignored. That's why it's called exonerating, because they didn't want to hear about the truth. They only wanted to support the narrative of the father. Why is that? The fear of paying child support because all he thinks about is money, and winning because he's probably a cluster B personality. The DRCB broke it down, and that is also exonerating and ignored. Similar patterns of behavior. Interesting. Attorney Nathan Vining refused to produce the exonerating psychological evaluation at our mediation, which I had to pay for. He refused. So I lost the joint custody that I had enjoyed before the demand for the psych eval. So I should have been reunited with my son immediately if my attorney, Nathan Vining, had done his job. But yet I was coerced into a supervised parenting plan by the opposing counsel, attorney John Cassis, with a person who's not even qualified to provide supervised parenting. She was unwilling, but yet she took the gig because John asked her to. How nice. Did I even know anything about it? No. Did I have any say-so in this matter? No, I did not. I was there to get joint custody and the assets that were due to me. But I got nothing. I got nothing but another boot up my posterior. Another pattern of behavior, I'll say. All of these delays and injuries have forced me into homelessness and into catching criminal cases, which I have also been exonerated from. No lawyer has stood by my side, except for 4 times. I have paid attorneys for 11 years now because I believed they were useful. I no longer trust them. I seek them out of duress, and I get information from them. The bad actors that gave opinions and abandoned us did so knowingly. This is a crime. And tried to extort money, which is also a crime, out of victims, myself, with a brain injury. I have PTSD. It is an injury. It is recoverable. It takes a lot of therapy. I was involved in therapy for 5 years at that time to recover from the PTSD caused by my ex. Science guides law, except in our family law case. In 2015, the DRCB report, the Domestic Relations Counseling Board, I think that's the name of it, report provided 2 attorneys when the attorneys made the scheme to loot my case, take the money, and ditch all efforts to justify anything. And they placed a child and an adult with brain injuries into the abuser's care and keeping, and yet we can't find justice. This is endangerment and failure to protect. It's also slavery, induced slavery, and due process violations, as well as First Amendment. And there's also the matter of 42 U.S.C. 1983, which I'm particularly fond of. My lawyer in 2015 became a super lawyer after dumping me. And the abuser's lawyer ran for mayor of Carmel. That would be Angela Swenson, who is no angel. Like the rats that they are, they abandoned our case when there was a huge question of my mental fitness and the child abuse was at hand. The guardian ad litem and both attorneys abandoned us, withdrew, never to return again. Even the guardian ad litem, who takes an oath to stay with the child as long as the case is active. So actually, this case was thrown by the attorneys in order to give an abuser a child, because the mother, of course, is going to continue to fight through the legal process for her rights. There must have been a mistake. They can hide behind immunity, and who really cares about her? So there's a point of view. I had contact with 3 of the opposing counsel's employees, and they didn't inform me of who they were. So could this be a confidence scheme? Of course. DCS provided hand-holding and gatekeeping for the abuser when the opposing counsel and no attorney for me would be present to guide the court in their decisions. They neglected the science. FCM, family, I'm not sure what it means, but Nola Hunt is her name, is an expert in name only and has the compassion of a televangelist. She cannot diagnose bipolar in 20 minutes. No one can. She ignored the 20-year-old psych eval that she claims to have read and the scientific data that was provided, and also the scientific updates in that 20 years. Bipolar is seen as many, many ways. Autism is included in that. 20 years ago, 20 plus years ago, if autism spectrum was even available to the diagnosis, would I have fallen in that category as opposed to bipolar? Possibly. And 20 plus years ago, was I impoverished? There's that. And also, was I inundated with people who are very bad influences? There is that. And then the stresses of raising a family single-handedly. There's that. Did she bother? No, she didn't. She was motivated to place a small child with a father despite all the given proof of his criminal history. What a numbskull. She failed to protect a child from a violent offender with a high-risk pattern of behavior plus a non-restrictive pattern of discipline for the child. He's either very non-restrictive or he's entirely overbearing. He vacillates between the two depending on his mood. He has never been scrutinized, and they were right there from the very beginning, and DCS is there currently. The child's injuries were never truly investigated because mom is bad and dad is good, and that is the black and white thinking that comes with cluster B thinking. So if they can't investigate enough to look beyond his narrative, they are aiding and abetting him, and they are not worth the taxpayers' money and the faith and confidence that we hold in them as an agency, because this is unbelievable. CPS did see the evidence of child endangerment in September of 2014. Nola Hunt neglected to warn the court. She, in fact, acted in a way to indicate to the court she supported father as she appeared with him at his violation of my protective order hearing, where he used a public defender, although making $3,200 every month. His financial affidavit states that since May of 2013, he makes $500 plus a week, and this is above poverty level just in and of itself. Nola Hunt, her report in family court was designed to release the father from his criminal actions and to place the blame for any wrongdoing upon the mother. This is malpractice. This is biased investigation, and this is child endangerment, which is current news, evidently, because suicidal is a sign. This is my son we're talking about. And 47 DCS reports looking to the father for neglect and abuse and not thoroughly investigating a pattern of behavior, that is malpractice. Nola Hunt knowingly placed my son in harm's way by the omission of exonerating facts. Magistrate Patrick Murphy and Judge Dreyer failed to demand facts and listened only to the opposing counsel. The dismissal of my attorney, Kevin Bowen, within 30 days of a life-changing hearing, who was provided a DRCB report that indicated that mother is the survivor of abuse and the target of abuse by the father, who is hostile. Kevin Bowen, my attorney, knows the law, and he knows bipolar, and he knows the time and distance regulations, and who ordered my spousal support hearing, but then withdrew anyway. How would things have changed if he would have stayed by my side in 2015, instead of being separated from the love and nurturing and the care of my child, and thrown into despair and impoverishment, and caught in the crosshairs of litigation, malicious litigation? He knowingly abandoned me, I with a brain injury, in order to face my accusers and to defend my son against false allegations of child abuse and mental health. Thus concludes Part 4, The Family Crisis.